katılımcılar, öğleden sonraki ilk oturumumuza hoş geldiniz. Bu oturumda Sayın Doktor İlyas Arslan.
Now we will be inviting our speakers, our panelists, Elif Beyza Akkanat Öztürk, and also İlyas Arslan, Ayşe Yasemin Aydoğmuş, Cannur Ercan, and Günseli Gelgel will be moderating the session. The floor is yours. Thank you very much. So this is the first time that I am attending our hybrid meeting. This is something very new for us. So we have more technical people than participants because we have certain participants, attendees attending their houses, and Yasemin and I will be co-chairing the session together. So first speaker, by the way, these are all my students, very valuable students of mine, and I work with them in my chair. For that reason, moderating the session is very crucial for me. İlyas and Yasemin, my dear students, actually I raised them, yes. And right now they are teachers and they are presenting great, they are submitting great presentations. We are just helping them, that's it. İlyas will be the first speaker. İlyas has already completed his doctorate dissertation thesis, and he is now the associate professor doctor in Kocaeli University, and he is going to be talking about some disputes. He'll be talking about the international jurisdiction of Turkish courts in disputes arising from processing or non-protection of personal data due to violation of contracts having foreign elements. I wish that I was there with you, but in the upcoming congresses I believe that we will be all together. First and foremost, before I start my speech, I'd like to thank the organizers, Personal Protection Data Bureau and Istanbul University Faculty of Law, and also Turkish German University Faculty of Law, and esteemed professors in the steering committee, organization committee. I'd like to thank them for their efforts and providing this chance and opportunity to me, giving that opportunity to me. And Günseli, hocam, how much time I have? 15 minutes, unfortunately, because program is very intense. 15 minutes maximum, please. Okay, I'll try to wrap it up. First and foremost, I'm going to share my presentation. I guess you are going to see my presentation on your screens as well. Yes, very esteemed professors, esteemed colleagues. I'll be talking about the international jurisdiction of Turkish courts in disputes arising from processing or non-protection of personal data due to the violation of contracts having foreign elements. I'll be talking about which courts are going to be held responsible and what elements of the law should be used. As you all know, the law on the protection of personal data numbered 6998, which regulates the conditions under which personal data can be processed and how this data should be protected, has introduced provisions regarding the legal, administrative, and criminal liability of data controllers in case of unlawful processing of personal data. On the other hand, the law numbered 6698 also regulates that individuals who have suffered damage due to unlawful processing of their personal data have the right to demand the compensation indemnity of the damage, and that the compensation rights of individuals are reserved according to the general provisions. There could be various contracts, such as contracts of agreements, also contracts, consumer contracts. Sometimes we see sponsorship contracts or else advertisement contracts. These are some rare examples, but they can also be certain examples. Unless they have foreign elements, responsible court is determined based on the judicial procedural law. And also credit giver, sponsor, creditor, and also advertisement agency and the employer. So if their places are located in abroad, or else if the other party is a legal person established based on the law of the foreign country, this is defined as the contract of including foreign elements. So I'll be talking about the violation of contracts having foreign elements and also the obligation for the protection of the personal data. As I've stated beforehand, we have to take the obligations from the relevant laws, but the previous laws that I have listed, such as the civil procedural law, can't be applied. At this point, in such cases arising from contracts with foreign elements, Turkish courts will first have to determine whether they are competent to hear the case in question. In private international law disputes, especially arising from the processing or non-protection of personal data in violation of the contracts with foreign element, it can't be correct for Turkish court to determine that jurisdiction according to the rules of Code on Civil Procedure. So, international law and procedural law number 5718 provisions must be taken into consideration, and the annulment and invalidity of the power of attorney agreement should be taken into consideration, and so we can determine the court based on certain articles of the CPIL. The legal nature of the contract should be taken into account in determining whether the international jurisdiction rule to be applied in such cases, and therefore the court in which the lawsuit will be filed has international jurisdiction. When the provisions of the Code on Private International Law and Procedural Law are examined, it can be seen that a distinction is made in the form of general special international jurisdiction rule in determining of the international jurisdiction of Turkish court cases arising from those contracts. According to special international jurisdiction rules, Article 44 to 46 of Code on Private International Law and Procedural Law have been established in terms of consumer contracts, employment contracts, etc. In this, if there is no responsible or authorized court with this respect, then Article 40 of the CPIL can't be applicable for this case. So what is the importance of this topic for personal data protection? So certain contracts like consumer contracts, employment contracts, insurance contracts that are under the jurisdiction rules of Article 44 to 46 of CPIL, we can say that, again, consumer contracts, employment contracts, and insurance contracts will be applicable for cases arising from all kinds of contracts other than these contracts for Article 44 to 46 of CPIL. So these three important international law are important for determination of the court. They say that when it's about insurance, employee, employer, and consumer contracts, these are the weaker part of the agreements, contracts. For that reason, relatively speaking, they are weaker than the other party of the contract. They must be protected. So in the legal civil procedural law or on the other domestic laws, remedies are not going to be sufficient. For that reason, these principles are mentioned. So between 44 to 46, jurisdiction rules are protective rules, and also 44 to 46 jurisdiction rules are limited, exclusive jurisdiction rules, because in the second paragraph of the article 44 and 46, it's not going to eliminate the local, the domestic law first and foremost. For the labor contracts fulfillment, employees' data, their families' data, their information, professional talents, health status must be obtained by the employer. So unless employees give correct information to employer, this is not correct, and it must be mutually respected relationship, and employers should be protecting the data of their employees. So if there is a violation of the rights or the breach of the protection of the personal data of the employees, if the employer breaches these relationship, if there is some damages over the trust, and the continuation of the employees working is something that can't be sustained at all, then based on the 44th jurisdiction rule of the CPIL, decrees are going to be made, and some courts are attained according to these establishments. Generally, legal regime of jurisdiction agreements in favor of Turkish courts in cases arising from a contract with a foreign element in which personal data is processed or where the data controller must protect personal data will be examined first. Then the effects of jurisdiction agreements which provide for the resolution of such disputes by foreign courts on the jurisdiction of Turkish courts will be discussed. Again, it is similar with the consumer contracts. If the information of the consumers are not protected, if there is a damage, then in order to compensate the damage, so the responsible Turkish court will be determined based on the Article 44 to 46. Yes, this is again the address information of their consumers and the economic status of that natural person, health status, also bank information. If this information is processed, we know that this is something important. This is again essential for the other party, but if it is misused, then it's also a subject for data protection rules, and there could be some obligations due to the contractual obligations must be fulfilled. So when there is this indemnity compensation case on the Turkish courts, they are going to take their basis from the Article 44 to 46 of CPIL. Again, there is this differentiation by the consumers and also the other party. So whoever is going to open up the court case, a jurisdiction and the court number will be determined based on that. So again, in the 46th article of the CPIL, broader insurance is mentioned. We can tell you that the articles on the CPIL is very crucial because risk evaluation must be made by the insurance companies, because damages and the claims could be compensated based on these risks, their health status, their sexual orientation, sexual health, and also professional situation. Everything must be taken for insurance companies to fulfill their jobs. So these insurance contracts are also deemed as consumer contracts. So according to 44 to 46 articles, implementation, there could be certain reservations. But here, in terms of insurance contracts, there is the special provision for this reason, and this kind of court cases arising from these contracts, again, the court is going to be determined based on the Article 44-46 and based on the consumer and also the insurance side, which party is opening the court case, that is determining the court and number of the Turkish court. If the agency of the insurance company is located in Turkey, or else if it has a representative in Turkey, then the Turkish court is going to be determined based on that. Parties of these contracts are natural persons, so we don't see big problems. But on the other side, on the labor contracts, employer contracts, consumer contracts, if contracts are not having these natures, so there are certain international jurisdiction rules which are not covered by Article 44-46 of CPIL could be also on our agenda. For instance, a sponsorship and also agent or else the athlete, when it comes to an advertisement agreement among these parties, personal data of the foreign athlete could be used again with a foreign TV company in order for an aesthetic surgeon to have broader audience in Europe, or a hair transplantation expert physician, Turkish doctor, professional, and personal data could be used. And also we are using cloud storing services with the foreign companies under the Professional Acts when there is this agreement with architects or engineers party with the iClouds. Their services could be also stored in virtual cloud, virtual stores, virtual closets. So personal data protection and processing of the personal data, which is not in line with the contracts. If natural persons want to open up a court case, then the jurisdiction of the court is going to be determined based on the 44-46 of CPIL, and it says that the legal regime of jurisdiction agreements of Turkish courts in cases arising from a contract with a foreign element in which personal data is processed or where the data controller must protect personal data will be examined first. Okay.
What are these courts? In the domestic courts, the first rule is the second article. It is the real address of the real person, and the litigations born out of agreements with foreign elements. In that regard, the location of the court is the international courts. Therefore, the parties, one of the actions, if it is fulfilled in Turkey, then we can say that the agreement is going to take place in Turkey. And in Turkish procedure law, the authority of the courts is about public order. The court, even if it doesn't have the authority, if they don't object to that, then this court becomes authorized. And in terms of such agreements, any court might have international authorization. Last but not least, the protection and processing of personal data. If it is mentioned in the agreement, and it might be used by the foreign party in the 105 article of Turkish Commerce, Code of Commerce. They can open a court case in Turkey. Therefore, the location of the court might have the international authority. On the other hand, in Turkish law, in terms of the agreements for protecting the personal data, a foreign court or a Turkish court or the article might not be there within the agreement, but in terms of the consumer and business agreements, those preparing the contract, and there might be such an article within the agreement. Therefore, in order to protect and process the data, personal data, the authority conditions, whether they are valid or not, this might be a matter of discussion in Turkish courts. The speaker is reading, so it's almost impossible to translate what he reads. And as a principle, when we look at those provisions will be applicable as well if the personal data is not protected and it's the matter of the court case. The provisions of the agreements, it's going to be different whether it's a Turkish court or foreign court. In Turkish law, the conditions of being legal and its legal results, their results have been regulated.
Sayılabileceğini burada belirtmek isterim. Bunlardan ilki şudur: Türk hukukunda Türk mahkemelerinin seçimini öngören bir yetki anlaşmasının sadece tacirler ve kamu tüzel kişileri tarafından yapılabileceği öngörülmüştür. Yine Türk usul hukukunda yer itibariyle yetki kurallarına ilişkin hükümlere baktığımız zaman sözleşmeden doğan uyuşmazlık bakımından kesin yetkili mahkemenin bulunması söz konusu olabilir. Mesela can sigortaları bakımından HMK'nın 15. maddesinin 2. fıkrasında yer alan mahkemelerin yetkisinin kesin olduğu ifade edilmektedir. Yine İş Mahkemeleri Kanunu 6. maddesinde söz konusu maddede yer alan mahkemelerin yetkisini bertaraf eden anlaşmaların geçersiz olduğu açıkça öngörülmüştür. Demek ki bu hükümler çerçevesinde şu sonuca varmak mümkün: kişisel verilerin işlenmesini ve korunmasını konu edinen sözleşmelerde yer alan yetki şartları HMK madde 17'de öngörülen kişi bakımından sınırlama nedeniyle geçersiz olacaktır. Tabi burada akla şu soru gelebilir hemen: gerçek kişiler bazen mesleki faaliyetlerini gerçekleştirmek amacıyla da sözleşme akdedebilirler. Mesela diyelim ki bir plastik cerrahın veya bir diş hekiminin muayenehanesinde kullanmak üzere satın aldığı bir yabancı firmadan satın almak istediği bir cihaz, tıbbi cihazla ilişkin olarak bir tıbbi cihaz satım, yedek parça ve teknik servis hizmeti alınmasına dair bir sözleşme akdedildiğini varsayalım. Bu durumda bu sözleşme söz konusu mesleki faaliyeti gerçekleştiren doktorun veya plastik cerrahın tacir olmaması nedeniyle muhtemelen geçersizlik yaptırımına maruz kalacaktır.
İlyas'cığım biraz süreyi açtık.
Tacirlerin aynı zamanda...
Biraz süreyi açtık İlyas'cığım. Çok güzel bir konu ama diğer arkadaşlara haksızlık oluyor. Biraz toparlayalım istersen.
Hemen toparlıyorum hocam. Yabancı mahkemelerin seçimini öngören yetki anlaşmaları bakımındansa şöyle bir durum söz konusu olabilir: kişisel verilerin işlenmesini ve konulmasını konu edilen yabancı unsur sözleşmelerde madde 47'de aranan yabancılık unsuru taşıma, borç ilişkilerinden doğma ve yazılı delille ispat şartları bakımından sorun yaşanmayacaktır. Ancak burada mevcut madde 47 aranan şartlardan uyuşmazlığın Türk mahkemelerinin yer itibariyle yetkisinin münhasır yetki esasına göre tayin edilmediği bir konuya ilişkin olmaması gerekmektedir. Bu tür sözleşmeler bakımından Türk mahkemelerinin münhasır yetkili olduğu haller, iş, tüketici ve sigorta sözleşmelerinden doğan davalar bakımından mevcut madde 44 ila 46'daki mahkemelerin yetkisi ve yabancı tacirler adına acenteler tarafından addedilen yabancı usulü sözleşmeler bakımından Türk mahkemelerinin yetkisinin şu an itibariyle münhasır nitelikte olduğunu söyleyebiliriz. Yargıtay'ın iştihatlarına istinaden. Dolayısıyla bunlar dışında kalan ve kişisel verilerin işlenmesini veya korunmasını konu edinen sözleşmeler bakımından sözleşmelerde yer alan yetki şartlarının geçerli olacağını, münhasır yetki söz konusu olmadığından dolayı geçerli olacağını söyleyebiliriz. Sabrınız için ve beni dinlediğiniz için çok teşekkürler. Vaktimi açtığım için çok özür dilerim.
Estağfurullah. Çok biz teşekkür ederiz.
Thank you very much. These matters should not be squeezed in such short periods of time, but the program is quite intensive. Now, our second speaker, Dr. Ayşe Yasemin Aydoğmuş, she is going to give us information about the law to be applied. Distinguished audience, distinguished professors and distinguished organizers, first of all, I would like to thank you for giving me this opportunity. And this is the determination of the law to be applied in litigations with personal data carrying foreign element. Data protection has become one of the most hotly debated topics in recent years due to recent developments in technology and communication system. Vast amounts of data can now readily be collected, stored, and transferred around the world. Currently, a wide range of personal data has been amassed through several methods, and as mentioned by Ihsan, including details of individuals' personal identities, health records, educational backgrounds, and financial affairs, such data has huge commercial value and considered as an economic asset. And these developments relating personal data have resulted in significant controversy and debate. The key concern of legal scholars and practitioners is how to balance data subjects' rights to privacy and security with fast, effective, and economic processing of the data, yet itself is important and necessary to provide individual and societal benefits. And as a result of these national and supranational bodies around the world have recognized the need to regulate the processing the data and acted accordingly. And Turkey recently had some regulations regarding data protection, and I will be examining the law to be applied to the disputes related personal data containing foreign element. And in the globalized world, real and legal persons often have a connection with more than one country, and in the case of private law disputes containing a foreign element, courts must first apply rules on conflict of laws to determine which law to apply to the case. Classification has a critical role in determining the law to be applied, and in the present case, the classification of data protection, whether violation should be classified as a tort or breach of contract will result in the identification of the law to be applied. And in the Turkish Code on Private International Law and International Procedural Law, numbered 5718, there is a specific article on personal data, and according to Article 35 of the Code, numbered 5718, infringements of personality rights resulting from the processing of personal data, as well as to impairments of the right of access to personal data, are governed at the option of the injured party by the law of the state in which the injured party has their habitual residence, provided the tortfeasor should have expected that the result would occur in that state, or by the law of the state in which the tortfeasor has their establishment or habitual residence, or by the law of the state in which the result of the infringement occurs, provided the tortfeasor should have expected that the result would occur in that state. However, experience shows that this article may be inadequate in practice. And mentioned article regulates only infringements of personality rights resulting from the processing of personal data and impairments of the right of access to personal data. And however, lawful processing of data and protection of the processed data have also crucial importance. And processing of data in a contractual relationship is a completely different issue to be examined, and the effects of the general conflict of law to be applied to the contracts and articles regarding to the specific types of contracts in the field of data protection should be definitely studied. And it should be remembered that overriding mandatory rules of the Lex VIII and third country related to the personal data can be applied due to the close relationship between personal data and states' economic, political and social approach, and the relation between cross-border application of the regulations like General Data Protection Regulation of European Union and overriding mandatory rules and its effect to the applicable law should be evaluated in terms of private international law, and if that person is the perpetrator, let's say, but when there's a problem about protection of the personal data, we need to define the court in MIHUK. There it's regulated within the article of 24, and this is the general rules of the contracts, and there are also specific contracts. And if it is carrying foreign element, when we categorize them as Turkish code in MIHUK, if it is within the scope of special contracts, then we will apply that article. If it is a business agreement, we need to apply the article of 27. And if it is a consumer agreement, then we need to apply the article 26. And if it is not among these special agreements, we need to look at the article 24. The parties should pick the law, and there's a comprehensive regulation in MIHUK how to select the law, and they can choose it, and this law can be applicable to the whole contract or part of them. The parties can make an agreement in defining so. Let's say that, Ms. Jelen is obligations and personal data protection might be handled differently, and it is possible to make amendments, but the amendments after the contract, third parties' rights are reserved. When they don't have any agreement, objective binding rule is going to be taken in this role. In Turkish code, if there is an agreement within the scope of Article 24, if they didn't select the form of law, then the characteristic agreement contract is being picked up. And the judge, within the framework of the concrete event, if that thing is more related to the agreement, then exception rule is going to be applied, and it is going to be about, let's say that the foreign comes to Turkey to get the hair implant, and then if there's stricter relation, then that law is going to be applied. And we know that the general arrangements are in the Article 24, but apart from that, we do have specific arrangements. In 25, for the immobiles, agreements about immobiles. In the 26, consumer agreements. In Article 27, commercial agreements. 28, intellectual property. And 29, the transfer of the goods about that. So I will handle a couple of them. In MHUK Article 26, consumer agreement has been defined, and in the CPIL, we can say that habitual residence is going to be taken into consideration. And at this very point, we can say that from a bank, you get a loan, or a foreigner opened a bank account in a bank, because while opening those accounts, personal data is being given, and while taking loan, sensitive personal data might be given. Therefore, this is going to be defined under the article of 26 of CPIL. But the consumer agreements characteristics, when we look at them, the consumer is weaker, less experienced, and that person needs to be protected. The habitual address is going to be the criteria of that, and minimum protection needs to be provided. Of course, if a law has been selected which gives more protection to the consumer, then it's not going to be an issue. If there is no selection of law between the parties in CPIL Article 26, not for all consumer contracts, but some consumer contracts, it might be applied. And if it is not in the scope of CPIL 26, then they are going to be subject to the Article of 24 of CPIL. And business agreements is the other one, Article 27. Business contracts do contain personal data, and even during the interviews, this person sends their personal data to the company, sometimes intermediary companies, and after the agreement has been signed, this data is still being used by the employer, like the social security, paying the salary. You know, these data might be shared with the third party, so business contracts are important. If there is an element, foreign element, then the parties have the right to select the law to be applied, and similarly there is a protection provision. The worker is weaker and needs to be protected, and the habitual residence law might be selected, but if there is no selection of the law, then the location, business place location, is going to be applied. Habitual office and also the regulation of the personal data and the protection of personal data is going to be up on the agenda, and in the 27th article of CPIL there is an exception provision. If the judge is, if there is law which is protecting that person more, then it's going to be applied. And last but not least, if in line with the CPIL, if there is a concrete litigation, if it is foreign law to be applied, there are two important elements. One of which is the public order, and the second one is the directly applied rules. If a foreign law is going to be applied, as a result of the fulfillment of that law should be in line with the constitutional, human rights and Turkish law. So it might be an exception. And about personal data, and there is another element, is the doğrudan applied rules, especially in the foreign doctrine about data flow, data transfer. Directly applied rules might be there. And thank you very much. That's all.
Ben teşekkür ederim. Gayet güzel kullandın süreyi Yasemin'cim. Sağ olasın. Ağzına sağlık. Aslında hakikaten içeriği çok kapsamlı bir konu. Biliyorum, farkındayım. Bu kadarından ancak biz bu toplantıda.
Thank you very much. It's been a very complex topic. I know that it requires broader inspection, but for this meeting intensity, I think this is more than sufficient. We have an online connection. Miss Ercan. She will be talking about violations in digital environment.
Teşekkür ederim Sayın Hocam. Canur.
Thank you very much.
Öncelikle Sayın Hocamı ve sevgili meslektaşlarımı saygıyla selamlıyorum. Değerli dinleyiciler.
I'd like to extend my salutations to all of you.
Teşekkür ediyorum.
And thank you very much.
Hemen vakit kaybetmemek adına ben de içeriğini...
In order not to lose more time, I'd like to extend my salutations, and I'd like to share my screen with you. And I have, I guess, 20 minutes.
Evet, Sayın Hocamın da dediği gibi dijital sözleşmelerinde kişisel
I'll be talking about the sharing of personal data as counter performance in digital content and digital service agreements.
detaylarıyla alınabilecek bir konu ama ben en azından
It's a very comprehensive topic, but
güncel gelişmeler olduğu için
it has subjected to some new developments. First and foremost, I'd like to show you this very general framework. As you know, we don't have any adjustment regulation in our law with respect to digital content. There is just the European Union directive, and it has a very long name.
tercümesine dijital içerik ve dijital hizmetlerin sağlanmasında sözleşme hukuku bakımından belirli bakış açıları hakkında Avrupa Birliği Parlamentosu ve Konseyi'nin 20 Mayıs 2016 tarihli direktif şeklinde çevirdim ama
It is the EU Digital Content Directive issued by the Council at the date of 20th May of 2019. European Union Digital Content Regulation and Digital Content Directive. Actually, this is the first step in terms of protecting the personal data. As we all know, personal data has become crucially important in the digital world that we live in. With the increasing of many smartphones, free applications, more and more service and content providers request to access and share personal information. It is undeniable that personal data provided by consumers can have financial value, even despite the fact that consumers do not pay for these so-called free options. It is well known that service providers collect and share personal data with third parties for various purposes, including consumers being targeted by personalized advertisements. However, compared to classical transactions, it is quite difficult to determine the exact financial equivalent. And we all know that we do not pay any money, but here we demand as the consumers some service in return of the content that we provide the other side. And so what is digital content? What is digital service? When we have a look at these definitions in the recital 19 of the directive, there is no clear definition, but we can also say that there is no differentiation between digital content and digital product. But in terms of directives, stipulations, when we talk about video files, computer games, digital files and electronic publications, and also data forms of electronic forms of the data, their processing, and also video and audio transactions that are also shared, and cloud computing, social media mechanisms and social media games are under this directive coverage. There is this recital, there is this regulation, and again in line with this directive, it's a very recent example in German civil law. There are new obligations brought for the German side, German citizens. In paragraph 327, it has been actually described in more detail.
İlgili hizmetin tüketici veya diğer kullanıcılar tarafından dijital biçimde yüklenen veya oluşturulan verilerin ortak kullanımı ve bu verileri
The EU Digital Content Regulation here, as I've stated beforehand, leaves the assessment of this question to the national law of the member states in the recital 12, 24, Article 3, and also Digital Content Directive. So time is very limited, that's why I can't touch upon the definitions of the digital content and digital service agreements. So are they really legally binding? Can they have legality like the cloud computing? So in BDB, what kind of an implementation was made? In the digital directive, digital content directive, there was no clarification, even though there is no very clear calculation. I can't unfortunately read what is written on the screen, says the speaker. Evaluations are left to the appraisals of the member countries' domestic law. Maybe I can give you this example from the German civil law. And if you have questions, I'd like to answer those questions. And maybe we need to define what are these personal data. Personal data is related to natural persons, so any kind of data of natural persons. Can they have financial economic values? Of course, the importance of this issue is definitely without a doubt very big, because there are so-called free services to us on the applications, on the computers. This is not a new model, we know that. And sharing our personal data, will it provide economic or financial value? We need to know that. This is the data economy. Actually, this is the subject of the data economy. Of course, they are financially valuable, but it is difficult to detect this value because there is no return of money in this free applications. We can talk about digital content providers. Strategies could be very much utilized with the information that we provide to them, or else they can from time to time sell our personal data to third parties.
Ya da hizmet sağlayıcısına paylaşılmış olması bir karşıedim oluşturur mu?
Does it create sharing of personal data? Does it create counter-performance in digital content or digital service agreements? So there is two parties, the ones who prepare the information to the other party, the one which is described here as the merchant. If there is this relationship, this directive could be applied. So here there is no counter-performance term in this law, but on the draft draft document, it says that consumer pays certain amount of money, and when it is the case, it might have the feature of counter performance. But there is this intentionally Gegenhauen. This word was taken out. Can the sharing of personal data be qualified as a counter performance? From the German Civil Code, that Gegenleistung, that word, counter-performance word, was eliminated. If the entrepreneur, the merchant, only uses the information provided by the consumer in line with the directive just to produce more content, then he or she will not be seen responsible. So, of course, the member states are going to decide, because directive stipulates member states take decisions for this kind of relationships, and it is the role and responsibility of the domestic law. And there could be some situations where the consumer pays some amount of money and also shares its personal data, and it is also mentioned in some articles on the personal protection data law, GDPR. But we have to underline one thing. Sharing the digital information, can we talk about a mutual agreement, or else is this an agreement which is dependent on a condition? So when we think of our own experiences, when we want to download an application to our mobile phone, we require to provide data. So either we'd like to share data, or else we don't permit, and unless we permit the data to be accepted, to be received, we will be deprived of the application or the service, or else it's going to be given to us in a limited way. So maybe we can say that. Other party can also ask personal data from the consumer based on the contractual obligations.
Günlük olaylardaki somut olaylardan daha makul gözüküyor. Fakat burada dikkat edilmesi
However, the thing that we need to apply one thing here, if it is dependent on a condition, by the way, this is all about personal data. We can provide our own consent, and we might say, I have given up sharing my content, my personal information. When it is the case, I am not allowed to reach that content. When I give up sharing the data of mine, I still can't have an access to this content. So because of these situations, they could be atypical contracts. They are not condition-dependent agreements. I'm not going to broaden the concept. So what happens to the rights of the consumers with respect to their personal data. If individuals share their personal data in order to reach a content or a service under the freedom of having an agreement, if they don't want to share their information anymore, what happens to them? Still, their information will be under protection, even if they permit, even if they allow other parties get their information, they are still going to be under the protection of the law. And in the recital 69, this situation is interpreted, and it says that this issue is to be evaluated based on the GDPR. Even there is this money relationship between these two parties. So these contracts under this concept, without a doubt, all the personal data must be protected under personal data protection framework, whether the consent is given freely or not, whether the contract is valid or not, will be determined based on the European Union General Data Protection Directive. When there is an erasure of the personal data and also rights to take back the secrecy and privacy of the personal data is not subjected to any kind of limitations, and it's going to be available on the European Union Personal Data Directive. And on the recital 19, there is this amendment: protection of personal data is a fundamental right, and it is personal data should not be accepted as commodity. And the thing that we need to emphasize is that it should not be assumed as a commodity, but if the consumers share their personal data, still they need the rights to have an access to their own personal data rights. This is the main purpose of the directive. So what are the limitations of the sharing of the counter performance? According to the law obligations, there could be the audit of certain obligations. And like I previously mentioned, personal data protection regulation should be applied for data collection, and we need to have a valid contract in line with the current GDPR, and coverage should be interpreted and necessity should not be exceeded. Ms. Ercan, we have already used our time. Yes, I am being warned all the time. I'm so sorry. I'm so sorry. I know the time is very limited. Okay. With these sentences, I'll conclude my speech. There are objective and subjective reasons, but I'm just skipping them. If something goes against these reasons, what can individuals do in terms of the personal data if they have already shared their personal data? Then Article 14 conditions must be implemented, or else consumers might demand the termination of the contract. When we have a look at the personal data again in the recital 68, 67, we can see this kind of an amendment. If the consumer does not pay monetary due, but still if the consumer shares his or her personal data, he or she can easily terminate the contract. And again, if money and also personal data are both shared, in these circumstances, when other conditions are fulfilled, digital content or the digital service must be corrected, and also the amount or the fee which is paid should also be decreased, or else the content of the digital product should be changed. Thank you very much for your attention. Thank you so much, and we are very sorry. You have already touched upon a great topic. I really know this topic in a very detailed manner. I'm so sorry because of the time limitations. You have to cut it short. Thank you so much. Now I'll give the floor to our youngest name, Elif Beyza Kanat. Elif Beyza Kanat will be talking about this directive of the European Union. I think she's going to be giving us more detail. The floor is yours, Beyza.
Böyle bir organizasyonda yer bulmak için ayrıca organizasyona çok teşekkür ediyorum. emekleri için. Ben hemen sayfamı paylaşıyorum. Böylece umarım görünüyordur.
There's a problem with the sound.
Sizin de isabetle işaret ettiğiniz üzere benim konum bu direktifin daha yakından ilgilenmesi ve karşıyım olarak ifade ederim. Bu direktifteki yeri. Planımı da şu şekilde sizlere sunmuş olayım. Sözleşme hukuku ile veri koruma hukuku arasındaki ilişki, özellikle dijital içerik ve hizmetlerin sağlanmasına ilişkin bundan sonra dijital ürünler diyeceğim bu ikisini de karşılamak üzere. Bu sözleşmeler bakımından oldukça tartışmalıdır. Hocam da daha biraz önce benden bunlara değindi. Bu kapsamda Avrupa Birliği'nde bu tartışmaları sona erdirebilmek umuduyla bir takım yeni girişimler söz konusu olmuştur. Bu ihtiyaçları gidermek adına ve 2019'da 770 sayılı direktifte bu ihtiyaca cevap olması umuduyla yapılmış bir düzenlemedir. Bu tebliğ kapsamında tüketicilerin bir dijital üründen istifade etmek için ürün sağlayıcısına kişisel verilerine işlenmesine rıza göstermesini konu alan direktifin sadece bu yönü esas alarak bir değerlendirme yapılmaya çalışacaktır. Ve bunun tabii ki Avrupa Genel Veri Koruma Tüzüğü ile uyumu yeri geldiğince ortaya konulmaya çalışılacak ve üye devletlerin de bu direktifi iç hukuka aktarırken nasıl tercihler yaptığı bu konuda biraz ortaya konulmaya gayret edilecektir. Veriye ilişkin bir takım bilgiler verdim. Bunları tekrar etmek istemiyorum ama verinin herkes bu yüzyılın petrolü olarak isimlendirildiği ve
There's a problem with the sound, but I will do my best. The harmonization of certain aspects of contracts for the supply of digital content and services across the EU via a specific directive, which is DCD, is a necessary legislative step. Some of the key questions about this regulation concern its aim and intended scope, especially whether personal data or data in general should be considered currency in the first place, since positions of the Council of the European Union, the European Commission, the European Parliament, and the European Data Protection Supervisor on these essential topics differ quite significantly. Substantive differences occurred between the proposed and effectuated version of the DCD. The aim of this presentation is to clarify the schema of the contractual relationship in which a consumer provides their data as currency for a digital service, or content with the scope of both DCD and General Data Protection Regulation. And in particular, it examines whether the general principle of synalagmatic contracts may work when personal data becomes currency, and it was determined that concept of data as currency should be maintained in order to protect consumers at the contract law level. And the relation and intersection between contract law and data protection law, especially in the context of the supply of digital content, have not been discussed, despite the regulatory activities in the European Union for creation of the digital single market. Outputs of these activities don't cover the expectation. In the digital economy and society, data has become the new oil, and personal data has evolved into a commodity because it's made readily available by users in return for benefits offered by companies in the form of services, discounts, bonus miles, giveaways, and the increasing practice of using personal data as payment in legal transactions poses new challenges for the doctrine of contract law and transactions. And the tendency in the market is to treat data as an asset and make data tradable. The main and only instrument helping to realize this neat tendency is anchored to contract law, and when we look at the protection of personal data, they are not discussed by regulators adequately, most particularly the new General Data Protection Regulation adopted in April 2016, which came into force in May 2018, was not sufficiently taken into account by the regulators in connection with the drafting the Digital Content Directive, which aims to regulate the contract law side of data-related transactions. And the proposal for a Digital Content Directive covers also contracts on supply of digital content, in which the currency of the consumer consists of personal data or other, and the key question that occurred in relation to the intended scope of the DCD is the above-mentioned currency definition, and other important questions include whether this type of data should have been considered and whether the scope of the DCT covers only actively provided data or all data flow, no matter if it is actively or passively provided. Because the positions of the Council of the European Union, the European Commission, the European Parliament and the European Data Protection Supervisor on the essential topics given differ quite significantly, substantive differences occurred between the proposed and effectuated version of the DCD, and here the financial dimension of the personal data, we cannot neglect them, and this is a legal qualification, and in order to do so we need to look at the quality of the relationships between the parties. Indirect arrangement can be provided while putting them in the scope of it, and it means the indirect acceptance of this de facto situation, because from the member states, Austria and Germany, when we look at their method of making GPDR into domestic laws, they adapted them to their domestic laws in different ways. Active and passive data acquisition, is it within the scope of the directive or not? Personal data might be, these personal data might be collected, and at this point distinguishing these two different groups is not necessary, and it's not in line with GPDR, because GPDR is handling the scope very comprehensively, and the omittance of this expression gives us the impression that passive data collection is also included, and here active data acquisition, and the discussions still linger at this point. But my opinion, from the perspective of the consumers, the purpose of the directive and the provision should be taken into consideration, and passive data collection should be within the scope of the directive. This is my opinion, and at this point, when we look at the contractual relations between the parties, this directive is also applicable, but the provisions, we can't see them directly. Therefore, when there's a legal relationship, there should be a legal basis for protection, and it's open consent, and for the fulfillment of the contract or the legitimate benefit, what should they be? That's the question, but we can say that being necessary for the fulfillment of the contract is accepted objectively, and this is handled, you know, this is the requirement for fulfillment. So for behavioral advertisement, if you use personal data for that, you can't use it because it's far from being the condition of the contract. And personal data, you know, if it is used as a substitution to money, if it is for paying the debt, then this is a situation which is accepted. And in terms of legitimate benefit, of course, this is a financial benefit. But when we look at the legal action,
kural olarak açık rıza olduğunu beyan etmek gerekiyor. Açık rıza hukuk uygunluk sebebi söz konusu olunca da geri alma hakkının ve bağlantı yasağı hükmünün bu direktifle nasıl bir arada ele alınması gerektiği sorusu ortaya çıkıyor ve bu soruda ne yazık ki direktif kapsamında doğrudan cevaplanmış değil ve geri alma hakkının etkilerinin üye devletlerin takdirine bırakılması söz konusu. Bu noktada Almanya geri alma hakkının kullanılmasının ya da veri koruma hukukundan kaynaklanan herhangi bir hakkın kullanılmasının sözleşme ilişkisinin geçerliliğine etki etmeyeceği yönünde iradesini açıklamak ile yetinmiş. Bu kapsamda geri alma hakkının sonuçları da direktifte düzenlenmemiş ve bu da üye devletlere bırakılmış. Almanya'da ise geri alma hakkı sonrası iş sahibinin sözleşme ilişkisinin sona erdirme imkanına sahip olduğu, eğer kendisi için çekilmez kılıyorsa bu ilişkiye devam etmek ancak bir tazminat tüketiciden talep edemeyeceği düzenlenmiş durumda. Bu noktada geri alma hakkının hukuki ilişki etkisi de ulusal hukukların tercihlerine bırakılmış, ulusal kanun koyucuların tercihlerine bırakılmış oluyor. Bu noktadan bir de bağlantı yasağı meselesi söz konusu olmuş oluyor. Yani GDPR'ın GDPR'ye 4 uyarınca öngördüğü bağlantı yasağıyla veriye dayalı bir sözleşme ilişkisinin kurulmasının ne oranda bağdaşacağı, ne oranda bağdaşmayacağı cevaplanmamak suretiyle geçilmiş oluyor. Son olarak direktif kapsamında en göz ardı edilen husus ise tüketicinin veri karşılığı bir hukuki ilişkide sahip olacağı imkanlar, yani tacirin borca aykırılığı sonunda sahip olacağı imkanların doğrudan madde metninde düzenlenmemesi. Kanun koyma tekniği bakımından ya da norm ihdas etme tekniği bakımından uygunluğu tartışmaya açık olmakla birlikte az önce hocamın da değindiği gibi Recital 67'de tüketicinin haklarına ilişkin bir düzenleme yer alıyor. Bu noktada normalde mevcut olan 3 hak, yani sözleşmeye uygun ifayı talep etme, bedelde indirim talep etme ya da sözleşmeyi sona erdirme imkanı, sözleşmeyi sona erdirme kapsamında önemli ölçüde sözleşmeye aykırılıklar bakımından kullanılabilir şekilde tasarlanmış direktifte. Ancak bu Recital 67 kişisel veri karşılığı hukuki ilişkilerde aykırılığın hocamın da az önce belirttiği gibi önemli olması kıstasının aranmayacağını, yani minor lack of conformity kapsamında da bu hakka dayanılabileceği, tazminat meselesiyle ilgili ise üye devletlerin takdirinin söz konusu olduğu, zaten her üye devlette sözleşmeye aykırılığa ilişkin bir tazminat hükmü yer altında bunun ayrıca düzenlenmesi ihtiyacının söz konusu olmadığı yönünde bir eğilimde ve yine hocamın da az önce belirttiği, tekrar değinmiyorum o sebeple, her iki hem para hem veri ödeyen kişiler bakımından, veriyle karşılığı ifade eden kişiler bakımından bu tüm hakların gündeme geleceğini kaleme almış durumda direktif. Sonuç olarak ben şunları söyleyerek tebliğimi neticelendirmek istiyorum. Direktif kapsamı itibariyle ilk taslak halinden bugüne gündemde kalmayı başarmış. Ancak veri karşılığı hukuki ilişkileri düzenleme alanına dahil etmiş olması yönünde tabii ki yenilikçi bir adım olsa da bu düzenleme kapsam ile ne yazık ki sınırda kalmış. Sözleşme hukuku esasları ve veri koruma hukuku kurallarının bağdaştırılması yönelik hükümleri doğrudan içermediği gibi düzenleme kapsamı itibariyle vaat ettiği sözleşme ilişkisi türünü, yani veri karşılığı hukuki ilişkileri AB düzeyindeki kaderini üye devletlerin iç hukuku bakımından yapacakları tercihlere terk etmiş durumda. Yani sonuç olarak ulaşılmak istenen hedefe, tek pazar ve kural belirliliğine temine yönelik bir adım olsa da bu adımdan ileri gidebilmiş değildir kanaatimce. Beni dinlediğiniz için çok çok teşekkür ediyorum.
Biz teşekkür ederiz Elif'ciğim. Biz teşekkür ediyoruz.
Thank you very much. Unfortunately, the program is very, very intense, and I'd like to thank all the speakers for their speeches. We don't have time We have already stolen from the next session's time. And I'd like to thank you very much for your participation. Thank you so much.
Bu turumda Sayın Doktor
Esteemed guests, in this session we have Dr. Cemal Başar, Dr. Yavuz Canbay, Dr. Merve Tunçbilek, Dr. Bilal Toprak, and Dr. Çiçek Ersoy will be moderating the session. The floor is yours. Thank you very much. Esteemed participants, esteemed guests, welcome to the 7th session. I'd like to thank Istanbul University for hosting this event, and also Turkish-German University, and also Personal Data Protection Board. I'd like to thank you very much, Dr. Cemal Başar. He is going to be talking about smart roads and protection of the personal data. The floor is yours. You have 15 minutes, please. Thank you very much, but the sound quality is too bad for translation purposes. We are going to do our best because the speaker is not currently using a microphone. It is very difficult to interpret the speaker's speech. First and foremost, I'd like to thank you very much and extend my salutations to all of you, and I'll start my presentation immediately. I'll be talking about intelligent roads and protection of personal data. So this is the outline of my presentation. First and foremost, smart protection systems, smart roads, and then I'll be talking about the concept of the protection of the personal data. After giving you some application examples, then we will be discussing the smart roads and protection of personal data. So we know that there is this rapid development in the information and communication technologies, also affects transportation systems. In this context, the use of intelligent transportation systems has gained great importance. Due to the importance of the subject, the Ministry of Transport and Infrastructure has prepared a national plan for 2020-2023, thanks to ITS, which is one of the smart city applications. It is aimed to increase traffic safety, shorten travel times, protect public safety with obtained data from cameras, maintain mobility, use existing road capacities effectively. So there is this road user driver. The systems developed for this purpose, which include multilateral data exchange and monitoring, measurement, analysis and control mechanisms between the vehicle, driver, infrastructure and a designated center, are called intelligent transportation systems. And at the end, as I've said it beforehand, there's going to be much more safety on the public side, and mobility is going to be also sustained, and road capacities will be used more effectively and efficiently, and carbon emissions will be also reduced. And also, thanks to these purposes, between the vehicle, driver, infrastructure and the road, communication can be sustained, and the journey could be maintained in a much safe and secure manner. And part of the information and data processed here must be in line with the GDPR and law on the protection of personal data numbered 6698. They are described as the personal data. Yes, okay. If we talk about the smart transportation systems, we can see different modalities. First and foremost, they can minimize the life safety, so they can minimize the traffic accident possibilities, and they can maximize the life security of the passengers, and also coordinates of the accident place could be very much easily detected through GPI systems, and comfort of the transportation could be also increased, and the time of the journey could be decreased, and timely intervention could be made by understanding the threats, and also certain risks could be notified previously to the drivers. And you can see an example. On the road there is icing, and you can also see some images with your smart system. This is dynamic dyeing, painting, when it is less than 0 degrees. So this situation can be activated and drivers can be warned beforehand. And also capacity of the road could be used in the optimum level, and mobility could be increased, and electronic payment systems could decrease the intensity, and also it could decrease the time losses, and traffic and maintenance of the driving systems could be managed much more easily. So all in all, in parallel to these purposes, we can see certain new systems on the road, such as certain cameras and also some traffic systems, sensors, meteorology stations, and also fog controllers, and some health and data collection centers. So all of them are gathered together and they create smart, intelligent transportation systems, as I stated before. And for these implementations, we can also talk about intelligent roads. So intelligent roads are the realization of the smart and intelligent infrastructure systems on practicality. And in our country, we also get use of this intelligent transportation systems. I'd like to give you an example. For instance, there is this event understanding detection system. So event detection systems send certain commands and orders when there is a passenger on the road, when there is a pedestrian or as animal on the road, for instance, or else when a car is coming reverse on the wrong road or reversely moved. It is also reflected on the screens, and operators can initiate necessary interventions, and gendarmerie personnel, also law enforcement officers, police or ambulance, they could be directed to the scene of the event. And let's talk about the personal data protection on this ITS, Intelligent Transportation System. So mentioned systems need various data in order to perform their functions, and an important part of this personal data are protected under the law on the protection of personal data number 6698, as we have stated before. And it's not only about protecting the data, but also the protection of the natural person that is related to his personal data. So with this concept of personal data, processing of the personal data should be realized under certain circumstances if it is detected, and if this scope is going to be outperformed, remedies and the means of the legal application should also be determined. So in this concept, the processing of personal data should be defined very well, and people should be given their controlling rights, and individuals have also been given their assurance for the protection of their fundamental rights and freedoms.
Bu noktada kanun kişisel verilerin korunması bağlamında esasında veri sorumlusunun
data controller is responsible for his own data. So this is what is stipulated on the law.
Veri sorumlusunun mesul olduğu bir sistemin benimsendiği anlaşılmaktadır. Bu bağlamda veri sorumlusunun tayini önem arz eder.
And the appointment of the data controller is very crucial, because obligations and responsibilities are on the burden or on the shoulder of this person, and this is defined on the Article 3A of the law number. All types of operations performed on the data starting from the first time the data are obtained, are considered within the scope of data processing. In this context, for a lawful data processing, first of all, it is necessary to act in accordance with the regulations. So what are these regulations? What are the obligations? In the law, we can say that there are many obligations for the data controller, and I'd like to give you some examples of the important ones that could also be applied on the intelligent road systems. First and foremost, personal data processing activities are very, very important because they are also defined in the law numbered 6698, Articles 5 and 6. These data processing conditions are regulated in the Articles 5 and 6, and also there must be attention should be paid to the general principles in Article 4 of the previous laws, and the exception provisions in Article 28, which lists the areas where the provisions of number 669 cannot be applied, should also be taken into consideration. So here there is obligations of the data controller is listed on the slide, as you can all read. In order for us to talk about the protection of personal data, that data must be processed. So as I've said it beforehand, the processing of the data must be in line with Article 5 and 6. And there is this differentiation based on the nature of the data, which is the special data or not. Explicit consent is required for the special personal data. Other than this, Articles 5, first two paragraphs must be happening. So either we get the explicit informed consent of the data owner, or else one of the two legality reasons should be available for the case. Of course, for the fifth article, I'm talking about fifth article's second paragraph. Irrespective of the existence of the informed or explicit consent, protection for the data should be provided. When we talk about processing of personal data, we can think of all kinds of processes on the data. And on smart intelligent roads, what could be the processings? For instance, you can get the names and surnames and also address of the residential area and mobile phone, email address, corporate information addresses, and also 11th article of the law number 6698, individuals' rights could also be covering the processing of this information with his or her content, and also the number of their passing systems, and also some images on the fee collection areas, some voice and sound and image records, and also sound recordings on the call center hotline calls. If there is a website about the road, collections of the information on the website, name, surname, credit card information, or else bank account numbers and taxpayer numbers, etc. All this kind of informations could be processed on the intelligent roads as well, and there must be some legitimate and legal purposes of data processing. You only have 2 minutes. You only have 2 minutes. I just like to remind you of that. Okay, for instance, on the highway operations, there is this fee collection purposes for payments and also debt investigations. Some personal data could be asked, and also we can say these people as customer and buyer, because they are served a service. And again, for the maintenance and repair services of the highway, when there is the possibility or probability of a potential crime, some data must be asked on the roads, and they could also be processed as personal data.
irtibat kurulması ve yasal yükümlülüklerin yerine getirilmesi kapsamında veriler işlenebilmektedir. Bunun haricinde yine çok sayıda veri işleme amacı karşımıza çıkmaktadır. Söz konusu, affedersiniz özür dilerim, söz konusu işlenen verilerin 5. ve 6. maddeye ayrıca 4. maddedeki genel ilkeler uygun olması.
Likewise, the position of data of the vehicle could also be determined, and video recordings could be taken with cameras, and processing of personal data should be in line with article number 4, 5, and 6, and they should not be kept always, forever. So, according to the law number 6698, based on this personal data storage inventory, they can store and keep the data for a limited period of time in certain conditions.
Bu konuda çıkarılan kişisel verilerin silinmesi, yok edilmesi veya anonim hale getirilmesi.
Anonymization and also erasure of the personal data law and the law number 6698 could be the valid laws when it is demanded by the owner of the personal data.
Bunları ifade etmek üzere imha etmek de diyebiliriz. Veri sorumlusunun yükümlülükleri arasında yer almaktadır. Söz konusu yükümlülüğün icrası için
there is this recognition of the right to protect personal data in the face of widespread processing of personal data, removes data subjects from only being a part of data processing, and gives them the qualification of being the subject of the right. In this respect, individuals should not be put in an unprotected situation as a data object against data processing activities. If there are some changes on the regulation about the storage and processing of the data, if person terminates his or her consent, erasure or destroyal of the personal data is asked, then by the data controller, personal data of the individual should be removed.
5651 sayılı yasa kapsamında 2 yıl süreyle saklanmaktadır. Saklama süresinin bitimini takip eden 6 ay içinde de bu verilerin imha edilmesi gerekmektedir.
Sayın Cemal.
Esteemed Cemal, Mr. Cemal, we have already exceeded our time. Can you please wrap it up? Can you please wrap it up? Because we have already exceeded your time. I'm so sorry, I haven't realized the time. Sorry. Again, the transfer of the data must be in line with the law. Data controllers should be also applying some precautions stipulated in the law number 13 and 14. Natural persons, if their data is processed, if they also think there is violation, based on the law defined for them, they have the right to apply at the court, and this is stipulated in the article number 14, and individuals, upon their application rejection, have the right to charge a claim to the Data Protection Board within 30 days. And thank you very much. Thank you so much. Thank you very much.
Söz konusu ihlalin giderilmesini veri sorumlusundan ister. Bu kararında yine en geç 30 gün içinde gereğinin yerine getirilmesi gerekmektedir. Akıllı yollarda çok sayıda akıllı ulaşım sistemi kullanıldığı için
in intelligent roads, many intelligent transportation systems are used. So naturally, too much data is processed, and some part of the data is subjected to the law number 669, personal data protection. and the others should also be evaluated based on the relevant law. This is obligation. This is a must. Thank you very much. Thank you so much. We have already exceeded our time. Thank you so much for your understanding.
Cemal Başar.
Cemal Başar made a presentation about smart roads and protection of the personal data. Thank you very much, Doctor. Now we are going to proceed with our next speaker, Dr. Yavuz Canbay. He's going to be talking about trend technologies in protection of the personal data. You have 15 minutes and I will be warning you. The floor is yours. Could you please open your microphone? Thank you very much. And I would like to thank to the organizers as well. My deep respects to you all. Let me share the presentation with you. My name is Yavuz Canbay. I'm a doctor in Kahramanmaraş Sütçü İmam University Computer Engineering Department and also the director of Smart Data Soft, and I will be talking about trend technologies in the protection of personal data. In the real world, represents himself with his existence, but when we look at the digital world, this representation is carried out by the data of the persons. And one of the most important outputs of the digitalized world is data. Data produced in many fields, from education to health and from finance to communication, is considered as personal data when it contains human defining features, and any data that directly or indirectly identifies a person is considered as personal data. When personal data is disclosed by attackers, the data subjects may be discriminated against or harmed by this situation. And when we talk about the privacy of the personal data, we need to prevent this situation. And in order to do so, and to make it difficult to reach the owner from the data, the concept of data privacy is of great importance. And we can see this concept of data privacy in the literature. There are a couple of definitions about data privacy: informatic selective control, or the decision-making mechanism to share the data by the data owner. If there is a personal data, its privacy is very important, and there are the attackers and also the providers of this privacy. And when we look at the literature, we can see that there are many types of attack, like the, registry attacks, some other attacks as well in the literature. And the most important element is the background information which leads the attack, because they should have collected background info before conducting the attack. And background information plays an important role in that regard, and this information is collected from the data published by various institutions, from social media, from audiovisual, from visual media, and from the real-world relations. Therefore, this information, any person, any attacker having this information with data clusters, when they conduct a matching attack, they can expose the privacy of that person. There are many attacks in the literatures, and what are the solutions? And when we look at them, in order to overcome these attacks, there are two important elements to look at. The first one is the passwording. This is used to make the data secret and private to that person. A key structure is being used, and data cannot be reached by unauthorized person. Only the password holders can have an access to this data. Homomorphic passwording and blockchain, these structures are being used within that scope. And another solution is anonymizing the approaches which make it difficult to define the identity of the data holder. And when we look at the literature, there are basic approaches of anonymizing, like the K, anonymity, L, variety, differential privacy, federated split learning. These are the examples of such approaches. The technology is developing in all the fields, like the big data, AI, Internet of Things, natural language processing. We know that because of the probable leakages, such structures of privacy protection is being developed as well in the literature, and such efforts are increasing in the literature as well. And it's important to create value out of data. And when we look at the processes in the protection of the personal data, there are two different ways. The first one is the data publishing with privacy protected, and you do have a personal data cluster and meaningful information. In order to omit meaningful information, you want to share it with the researchers, and before sharing it, that data cluster should be privacy protected. This is it. But at the currently, if you do have a data cluster, instead of it, you might ask a data analysis within this data cluster, and there are a couple of solutions in the literature protecting the privacy of the data. At the beginning of 2000, data protection, data privacy protection was approached by basic technologies, but along with the rise of trend technologies, they are now being used. At the beginning of 2000, for example, K anonymity approach was put on the table, and afterwards L diversity, T convergence, etc. Different technologies have developed. These are considered as classical technologies, and they are still being used nowadays. But when you look at the evaluations, such approaches are obsolete, and new technologies are coming up, and especially the trend technologies of the protection of the personal data. When we look at them, differential privacy, blockchain, federated learning, split learning, these are the updated technologies, up-to-date technologies, and we know about them now. Let's have a look at these technologies. Differential privacy was proposed in 2006, but it's still being used nowadays because it has been proven mathematically, this technique, and it's still being used in many mobile phones and big databases. This solution is comfortably used by many. And differential privacy's basic mentality, when there is an interrogation to a database, instead of reaching the real data, it is about the noisy data reach. This is the differential privacy process. There is a researcher and there's, let's say, user and a a database with sensitive data, and this user would like to make an interrogation in the database, and as a result of that interrogation or search, the real answer passes through a differential privacy mechanism, and the real answer is added a noisy answer, and the researcher instead of reaching this database, and this is the general approach of differential approach. And blockchain. Blockchain is distributed within the network, and it is being recorded, and it is distributed. It is transparent and cannot be changed. It's a safe data structure, and this technology is being used in cryptocurrency, but this technology is privatized in some fields, and the privacy of the data can only be provided after that. Here, the transaction data in the blocks, they are being put passwords or coded. The health data, the patients, like the cloud, like the research institutes, the information is being used by protecting their privacy. They are using blockchain, and we can find it in the literature. And in the energy sector, for example, the amount of electricity used and also distribution of the invoices to the distribution company, this technology is being used. As I stated earlier, what matters here that the data is being shared by deciphering and federated learning. This is important for those researchers of AI. This is a current and new technology. This was put on the table by Google in 2016 while developing AI application. The most important challenges were not being able to reach the data. You are going to develop an AI, but the most important part of the AI is to feed it with data. But the people, the institutions, and the data is personal, and the data is sensitive, and they're not eager to share the data. And here, increasing the awareness level, and this data can be used without sharing. This is a very good technology. It's showing it, and in finance, in health, in smart city, all these areas are going to be reshaped with this technology. And we see many foreign articles and research results in this field, but we haven't seen any research in Turkey yet, but there's only a few. But of course, I'm sure it will increase, having a meaningful value or output out of data without sharing them. It has been proved by federated learning system. Let's say that you develop an AI system, an email, whether it's spam or not, it can be classified. And in such a situation, what do we need? We need data. Therefore, the correspondences, the email information, and without them, it's not possible to differentiate the email from the real email, spam email from the email. Therefore, personal email addresses should be transferred to provider, but among these correspondences, there might be some sensitive info. Therefore, there is the problem of data privacy. Last 1 minute. So, the demander of the data is being kept on their side and it's not shared by anyone else. When we look at this diagram, there is a special server structure, and you can see here the hospital 1, hospital 2, and they do have their unique model, and the hospitals are not sharing the data with the server. With the models, they will be analyzing the data, and they can use the output. They transfer the output of the data to the server, and along with the parameters that the server gets from the hospitals, they distribute the data to the rest of the part. And in 2018, MIT developed another learning model, which is split learning. The main learning model has been separated into parts, and each piece has data, and the data cannot be shared with any other party, and data privacy is being provided. And there is a deep nerve network structure. There are two different parts of it. One is developed on the demanders, and the other ones are on the server. They're split. The hospitals are the demanders, and the server, the hospitals are using some parts of the model, and the values are being sent back to the server, and the final model is being educated, and then the results come back. This is my presentation. If you have any questions, these are my contact info. Thank you very much. Thank you very much, Yavuz Canbay, Mr. Yavuz Canbay, for informing us about up-to-date technologies about data privacy. Now we are going to proceed with our third speaker, Merve Tunçbilek. The floor is yours.
Süreniz özellikle riayet etmenizi rica ediyorum.
Tamam hocam, teşekkür ediyorum. Ben de saygılarımı sunarak başlamak istiyorum. Kritik altyapılarda...
Thank you very much. I'll be talking about critical infrastructures and a review of personal protection in critical infrastructures. A study in aviation industry. I work in the National Aviation Authority, and with the impact of technological developments, our country has entered a rapid digital transformation process in line with the ever-changing social demands and needs and reforms trends in public sector. The digital transformation carried out in the fields of big data, artificial intelligence, national technologies, and cybersecurity also shows itself in important sectors that show rapid development and growth in the world and in our country. And the transportation sector, according to national security and national cybersecurity strategy and action plan, is one of the critical infrastructures, and it is very much affected by the digital transformation, and it is one of the critical infrastructures. So what is a critical infrastructure? It is defined as infrastructures that host information systems that can lead to loss of life, large-scale economic damage, national security vulnerabilities, or disruption of public order when the confidentiality, integrity, or accessibility of the information or data they process is impaired. If we focus on the loss of life and disruption of public order, protection of personal data is very crucial. In the transportation sector,
mal veya hizmetlerin bir yerden bir yere taşınmasını güvenli, hızlı, düzenli, rahat, ekonomik ve
movement of goods and people must be carried out in the safest way possible. This is very crucial, and
ulusların başından geldiği de bilinmektedir. Bu yüzden de dijital dönüşüm
we know that transportation sector is very critical for the transfer and movement of information, and I'll be touching upon its importance later on. And aviation sector in Turkey is increasing its importance in our country. This sector is at utmost importance because of our geographical condition and also the distance of the flight, and we are among the top ranks of Europe, so aviation sector is among the most crucial sectors for our country. Due to its nature, aviation sector should provide fast and secure and safe transportation, so it requires some biometrical data-driven personal data processing conditions. Yes, these data must be processed. So since you entered the airport till you are seated in the aircraft, you have to be providing your personal data. That personal data-driven, biometric-driven personal data must be processed. As you all know, law number 6698, personal data protection law, includes the certain consents for the processing of the personal data, let it be private, special or not. So in this respect, all the institutions and people, individuals, they have to have their consent agreement texts. And if I'm talking about this personal data for aviation sector, we can see biometric driven data and also other kinds of personal data are under the protection of the personal data law because they are deemed as personal data in this respect. And in the processing of the personal data, there is this obligation of enlightenment, there is this obligation of consent. So these texts should be prepared. This is very crucial for the assurance of the quality of the text. It is important for both natural and legal persons. And the purpose of this study is to see whether there is compliance of the companies active in aviation sector, and
kritik altyapılarda kişisel verilerin korunması konusunda havacılık sektörü öne çıkan sektörlerden biri.
Aviation sector is very critical for the protection of the personal data. This critical infrastructure sector is where the citizens get their services and their needs are met. We can understand that if there comes any disruption or damage over this system, there could be many losses over the society. For that reason, these services should be given on a continuous basis with assurance and warranty. For that reason, it should have some capabilities and features. And in this study, websites were used and websites content analysis were made, and some airport and terminal operators in public institutions were included into our study, and also some airports licensed by the National Aviation Authority in Turkey. Websites strengthen the interaction between stakeholders, and they are used as a communication tool, including an information security policy on the websites of institutions and organizations is important in terms of providing stakeholders with a commitment to keep their information safe, and it is also important for gaining competitive advantage with the reputation of the organizations. For that reason, we have chosen this analysis method. And in the study, web pages of 32 organizations operating in Turkey were examined, and it was seen that one web page was used for a different purpose. It is also understood that five of these websites belong to the same group, and their websites and policies are supported by the group they belong to. So most probably their information security policies are determined on a central level. So if we talk about the findings, it is stated that 7 of them have ISO 27001 Information Security Management System standard. It has been observed that policies have been published in 5 organizations for the protection of personal data. In 17 organizations, it is seen that information is given about the processed personal data, its purpose and storage period. In terms of percentage-wise, 50% of these institutions have already included illumination texts, texts, and it's also observed that 3 of the airlines fulfilled their clarification obligations to GDPR with the idea that they directly serve the residents of the European Union.
Bilgi güvenliği yönetim sistemi politikaları aslında temelde kişisel verilerin korunmasına yönelik politikaları da kapsama almaktadır. Ancak elektronik ağlar üzerinden gerçekleşen
in the context of the protection of personal data, there is an approach that the data is not always processed. The aviation sector is one of the sectors that requires the processing of personal data up to biometric data. Features such as quality, speed, and economy of the services offered are possible by processing such data. However, the legal framework created by GDPR and personal data protection law does not allow the processing of the aforementioned data. Issues such as mandatory integration needs in order to provide passenger data flows with the third parties prevent implementation of projects due to the infrastructure inadequacies in some organizations, and the clarification obligation must be definitely available for the owners of the data to be aware of their rights, and it should also be providing benefit to the owner of the data. So what do we mean by this? It's not just a formality to fulfill, but it should also be understood by the data owners. It's not something that when you write a clarification obligation text, it's not something sufficient. Also the third parties and also the party which has the data at his hand should understand this text.
Kişisel verilerin korunması bağlamında kişisel verilerin her zaman işlenmemesi yönünde bir yaklaşım söz konusu olamamakta. Kanunda da gördüğünüz üzere bu konuda bazı
and in the law we see that there are some some exceptions, but in air aviation sector we can't see such exceptions because this transportation method is very fast and safe and secure. So this information is a must. We can't see any exceptions here. GDPR and personal data protection law does not allow the processing of this data, as before I mentioned. Issues such as mandatory integration is needed so that the passenger data flows could be provided to the third parties, but I just want to mention the results, and also the conclusions and the recommendations. Measures for the protection of personal data should be determined by national information security policies and based on certain standards. Cyber incident response teams which carrying out activities for the purpose of eliminating cyber attacks on information security, minimizing possible security risks, coordination and cooperation at national level, and also specializing in critical infrastructure sectors in Turkey. With the establishment of CRT teams within the scope of information security, The internationally valid is ISO 27001 certificate, which is taken as a guide and complied by the third critical infrastructure sectors, has been a driving force in areas such as identification of the assets, etc. So, by the way, these sectoral CRTs, corporate CRTs, are very crucial for the coordination and cooperation at the national level, and they are again effective for the prevention of the violations of personal rights and freedoms.
Hayati önem taşımaktadır. Kişisel verilerin korunmasına yönelik faaliyetleri kuruluş temsilcileriyle koordinasyon mekanizmalarında kurularak sağlanması elzemdir.
And it's very essential that these mechanisms should be functioning in line with the relevant institutions. There must be coordination and collaboration. And control articles and also the precautions should be understood by the personnel and the passengers. And this is very important because personnel's awareness and adaptation to these changes could be increased. And also internal control and audit mechanisms on sectoral basis will ensure that the rules for the protection of personal data are clarified. In this context, the guides and guidelines prepared by Personal Data Protection Authority can provide certain directions to us. However, the inclusion of the sector representatives in the legislative work and the establishment of mechanisms through which the feedback regarding the needs arising from the aforementioned projects can be conveyed to the authorities is of great importance for business continuity and for the sector representatives to strengthen their technical infrastructure. Thank you very much for listening to me. Thank you very much. You were really good at keeping up with the time. Thank you very much. And now I'll give the floor to next speaker. Last speaker is researcher, lecturer Biral Toprak. We'll be talking about blockchain, data protection and GDPR.
Hocam çok teşekkür ediyorum.
You have 15 minutes. Thank you very much. The floor is yours.
Mümkün olduğunca uymaya çalışacağım. Bugün blok zincir veri koruma ve genel veri koruma tüzüğü konusunu anlatmak istiyorum.
I would like to talk about blockchain, data protection and general data protection directive, GDPR. First of all, I will be talking about blockchain technology and then an overlook of GDPR and their relationship and general evaluation. This is my plan of presentation. Blockchain technology, you know, everyone knows about that because of the Bitcoin. This is a software architecture, and this technology is getting rid of the intermediaries, and the parties don't come face to face, but they can do transactions. And for many, blockchain term is equal to Bitcoin, but the underlying technology is forgotten, but it might look scary. Therefore, the basic concepts might be evaluated. Bitcoin and similar technologies, distributed and open blockchains, peer-to-peer networks, they are being shared and there is no intermediary. People can make transactions directly with the other people, and transaction data can be seen within the blockchain and everybody can join in that. P2P networks, blockchain is providing the integrity. And the main components of blockchain is to have communication without any center. P2A networks are being used and there is no intermediary. Each blockchain has its unique rules, therefore there is no one type of blockchain and each system has their own characteristics. The hash functions, you know, in order to understand how blockchain works, various mathematical processes should be evaluated. Hash is providing the integrity of the system. Hash is a text which is at the length, not a certain length, and then it's being transformed into a certain length data, and they're being used as digital print, and this is being used in digital signatures. And in order to, you can also use hash whether the data has been changed or not. The hash value is going to change if the data is being changed. Therefore, you can understand whether the data is changed or not. Let's say that merhaba, the hash value changes when you write it with small letter, and hash puzzles. In order to solve that, you need to make calculations, and these puzzles can only be solved with key combination. You need to try all the combinations. They cannot be solved without that. It takes time, and it's a calculation problems. Asymmetric cryptography, general and spatial key, blockchain, not on the hash, unlike the hash puzzles, asymmetric passwording, mathematical system is being used. Asymmetrical cryptography, the data is being used. There are two different key clusters are being used, and there is also one key for password. Ahmed is using symmetrical cryptography, and both sends an encrypted message to someone, and they will need to use different and private keys. In blockchain system, each unique user has a private key, and along with that private key there is a public key as well, and the public key is open to everyone, and with these keys the transactions can be made, and distributed registration systems are being used, and it's decentralized. There are banks keeping the accounts of people, and this is there to make sure that that person owns them, and it's like an inventory list of what that person has. But in blockchain, the ownership is defined differently. Current ownership registry is not being kept. Blockchain is using the log, and transaction data is being kept, and not only in one single place but in many places, and each transaction is being registered. And in order to have trust in blockchain, the integrity of that log has to be done, because if it is changed, then blockchain doesn't work. And verified ID, if they're being used properly, some steps have to be taken. Hash references and transaction levels are being checked in that regard, and they're keeping notes of that, and it's like chain, that's why it's called as blockchain. And when we look at the data structure and the blocks, the data structure of blockchain, it's like the books in the library, it's like that, a catalog system. There is no chronological system, but blockchain data has a card chain. The previous one is making a reference to the next one, and transaction data is being kept in a structure like tree, and a couple of blocks make the blockchain, and block high-level information is being kept for the previous block, and each block is making reference to the first and previous, and then they make chain, and as long as you know the last chain, each block has a reference for the previous one, so you can follow the whole chain. This is what I want to say about blockchain, and this is the outlook for GDPR, and for data protection, this is the new era, the beginning of new era. It entered into force in 2018. There are two basic elements while discussing GDPR: when and whom this is going to be applied. Real or legal person, it doesn't matter. This is valid for everyone. For this reason, some definitions needs to be discussed first, and then the relationship with the blockchain. I will be talking about that. There are some concepts within GDPR. I picked a couple of them. Personal data is the essence of the regulation. You know, this is personal data, data processing, and data responsible data and data processor. It needs to be defined, you know, in the GDPR, and all the definitions have been made, like the pseudo naming. This is to make it more difficult to have an access, and it is different from making it anonymous because it's revocable. You can change it back. I'll be touching on that again. And data processing, it might be automized way, or personal data clusters, any kind of transaction or a cluster of transactions. And data controller, the aim or the devices of personal data processing, they define, they're authorized to an institution or a person. And data controller, while defining it, the aim and the devices of data processing need to be defined, and data controller is processing the data on behalf of the data owner. It might be either an institution, so there need to be a data controller in order to have data processing. Many rights have been regulated in the regulation in the GDPR, and in the 12th article, you know, the rights of the data owner, informing, access, correction, erasure, delimiting, etc. And there are some other rights as well. And according to the 21st article, they might object to processing, and the data controller needs to answer all the applications, and if he has any obligations, they need to fulfill them, and they need to take all the precautions to provide the security. And the relationship of the GDPR and blockchain, the basic principles are valid for blockchain system. Therefore, the responsibilities or the rights provided by GDPR, the key actors should be associated, and data controller and data processor, each participant in blockchain, each who is the data collector. We can say that the designers, the technology designers, they are designing the technology, but they are not in charge of the starting it. The first creators of the blockchain, they are defining, they don't have the authority to define the devices, but they cannot be defined as the data controllers, but these designers, they need to be in line with the rules, especially required by the design. They need to be respecting them as well. And we think that they are in the scope of GDPR. The developers and the operators, blockchain is controlled, they are being owned, and in some systems, who made the transaction, when that transaction was made. Sometimes it's not being found out, but developing it, then marketing it, and launching it, you know, one or more operators are out there, and these operators or developers are providing the control to some extent, and these developers and operators can be considered within the scope of GDPR as well. And miners, you know, in blockchain systems, miners can be accepted as the data controller because they are approving the transactions, but we need to answer whether they can define the purposes of data protection. Then if we can say yes, the miners are the data controllers, ordinary users and participants they use them P2P basis, and the ledger has the copy of that, so the user of the blockchain can be considered as a data controller, and GDPR is applicable to all who can be considered as data controller. And 26th article of GDPR, the demands which may arise by the data owner, who is going to be in charge and who is going to make the notification. It's not clear within the blockchain system. Personal data within blockchain system, there are two types of personal data: distributed registry system, stored personal data, and general keys. When we look at them, these data is being used in blocks. You know, this data might be about a real person, which can be defined or non-defined, and in order to separate them from the others, we can call them as the transaction data. This data is encrypted within the chain and block information, and they are being anonymized, you know, to a certain extent or not. This should be evaluated. And before the regulation, the directive, you know, there was an evaluation by the working group, 29th working group. As a result of hashing, it's possible to associate that the owner of the data, and this is like the pseudo naming, not the making it anonymous. And when there is the technique of pseudo naming, it is within the scope of GDPR, and most probably this data can be regarded as personal data. And if we are to look at the general keys, this is being used, you know, it's a letter or number, and this general key, if it is not matching to someone, then they cannot be attributed to a certain data owner. In order to have that as the anonymously, the identity should be prevented, and general key, you know, when we look at the distributed and registry systems, because of the asymmetric system, definition is possible. When we look at the regional scope of the regulation, blockchains are working on the systems all around the world, and the content creators, they don't have any control. And regulation says that the transaction is being made in the blockchain, whether it's inside or outside, and the expanded scope of the regulation, it's going to be applicable to many blockchains. And the third one, another matter that's worth mentioning, is that many transactions in distributed systems, it's the limit, and the regulation processed or data which has been transferred to a third party and it's being aimed at processed, there should be some conditions to be fulfilled first. And in theory, the protocol of blockchain can be designed by taking those issues into consideration. And there are the rights of the data owner. Please wrap up in a minute.
Estağfurullah hocam, hemen hızlanıyorum. Bazılarını inceleyeceğim. Tüzüğün 15. maddesi uyarınca bir veri sahibi.
In line with the 15th of the article of the GDPR, whether the personal data is being processed or not, and that person has the right to have an access to that personal data, and it's not possible to use it in the blockchain because the data controller cannot know which part of the data is encrypted or not, and to erase is, you know, conflicting with the blockchain directly, because the data structure of blockchain is not compatible with this demand, because the rest of the data is going to be changed, the hash function is going to change, and because of the mathematically encrypted system, it's not possible to take something out from the ledger, and it's impossible, almost impossible to do that. An objection right to object cannot also be used, and last but not least,
Küçücük blok zincir kullanmaya başladığı tarihten çok sonra yürürlüğe girmiş
GDPR entered into force after blockchain, but P2PR and blockchains were not considered. Countries like Liechtenstein, they say that they need a lighter approach and actions need to be taken for blockchain. There are two ways to go. The first one is the adaptation and the second one is a new arrangement. And if we can provide an adaptation, all the blocks are going to be illegal within the scope of the GDPR, and for the following ones, new arrangement can be made. But if a new arrangement is being made, then the regulation can take necessary precautions to protect the rights of the person. This is what I wanted to say. This is quite a technical subject. I tried to convey the message in a simple manner. Thank you very much. We are right on time, and I adjourn the 7th session of today. Thank you very much. I would like to thank all the speakers for their valuable presentations and for updating us. And see you in the 8th session. Thank you very much. Next session is going to start within 10 minutes.
Değerli katılımcılar, bugünkü son oturumumuzda Sayın Profesör Doktor Güneş Peşke, Sayın Doktor Yasin Aydoğdu.
Welcome to our 8th session.
Sayın Profesör Doktor Perihan.
I'd like to invite our panelists and moderator. Profesör Doktor Yüksel Metin, Selda Güneş Peşke, Yasin Aydoğdu, Lütz Peşke, Perihan Elif Ekmekçi, Latife Büşra Çokaslan, Mehmet Akçaal. The floor is yours. Thank you very much. Welcome to the first International Congress on Personal Data Protection. We are in the second day's last session, and in this session we will be having 3 presentations, and these are related to current topics. And first and foremost, there is this presentation co-authored by 4 people. Yasin Aydoğdu will be talking about Hayat Evesar application, Life Fits Home application, and personal data in this application and these applications compliance with the personal data protection law. Please confine yourself, limit yourself with 15 minutes. Mic, please. First and foremost, I'd like to give you some information about the team of which behalf I'd like to present this presentation. This team are some of the members of Presenta team, provided the donation by Horizon 2020 project of European Commission. Selda Güneş Peşke is the project creator, and also there is Lütz Peşke from Bilkent University and from Ankara Yıldırım Beyazıt University, Aybeniz Alkan, and I am also another member of this team. I'd like to extend the salutations of my teachers, my professors and team members. I'll give some information about our project, and I'll start my presentation immediately. Thanks to this project, European Commission tries to have a very effective cooperation between academics and industry, and the contribution of pandemic over science and vaccination. The European Commission has tried to create awareness and effect over the society. This project was to be completed in 30 minutes, and at the end of this project presentation you can have some detailed information with respect to the application to this project at the end of my presentation. So this Horizon project and also Pandevita project partnership and Life Fits Home application give us a very crucial information, because we know that individuals and individuals' personal data has gained a different dimension with respect to digitalization. So starting from 1990s along with 2000s, thanks to the Web 2.0 revolution, Turkey has made huge investments in digitalization arena, and some special units have been founded under the auspices of the Ministry of Health, and more than tens of applications have been already gained to our lives, have been provided to our lives by Ministry of Health. Irrespective of foreigners or citizens of this country can use these implementations. And among these applications, certain applications have become much more dominant in our lives. For instance, the Life Fits Home application, which has become available after these Wuhan and Chinese COVID-19 pandemic. There are affiliation, isolation, monitorization system, and some other applications. But among all these applications, with the gradual normalization, Life Fits Home application has become much more available in our lives, and there is a code in this application which permits us to enter into different places. And these applications are similar to one another in terms of their functions, but in terms of, again, personal data protection, there are certain technical differences. So in the world, there are different applications, as I've stated, and in Turkey, we frequently use VIII application, has application. Who are the users of these applications? If we ask this question, maybe we can answer to that with this very comprehensive sentence. Like the health institution, health employees, medical companies, health professionals, insurance companies, social security institutions, and social insurance companies, underwriting companies, and medical hotlines, medical call centers, and also medical device and some other centers. They use this application. These are the users of these applications again. This application has been used by almost everyone in the society, but technicalities of this application could be summarized in this way. There is a special code specified and identified to a person, and the control and the use of this code is under the responsibility of the person. It is to follow the pandemic's trend, and locational data is processed here. It aims at securing the health among the society, and also the person's health is again processed here. Up until now, in the mobile devices, this application has been updated more than 25 times. When it was developed, in its initial phases, it was used for the following up of the patients, and when the pandemic was intense in certain places, it was just used for the monitorization purposes of the disease. But in June 2021, with the gradual normalization, with the elimination of these bans, prohibitions, this application's code has become obligatory in some mass transportation vehicles and some restaurants, some shopping malls. So it has become an obligatory, and it has been used very frequently by the users. But when it comes to personal data protection law, we can say that it's also an area for our interest, because it is based on geographical location and it includes some personal data of the people. But it has been declared by the Minister of Health, the very purpose of this application is to protect the health and well-being of the people and the society. Who are the users of this application? The ones who are under the registration to this application are the users of this application. For instance, all the Turkish Republic citizens among us are users of this application, and also foreigners who had this blue card, and the ones who used to be Turkish citizens and left the citizenship, and also the asylum seekers and refugees. By the way, the number of the refugees is very high in our country. In the very beginning of this pandemic, these issues were very problematic, but the provincial migration authorities enabled these people to have an access to application and receive a code. So we can say that, excluding the unregistered people in our country, everyone can enjoy the code and can use this application. By the way, this code could also be received from the e-state, e-government website. If you don't want to use this application, I'll be talking about this. Data minimization is also considered by the Ministry of Health as the data controller, because when we download this application, in the first part with this clarification obligation text, what kind of data is asked is mentioned, and your ID number, your gender, and also your mobile phone are asked. If you're a foreigner, then your passport number is required. So communication data is important, as I've said it before, and your phone number is needed. And by giving your location services permit to the application, your location is also registered on the place, whether this person has COVID history or not, and PCR test results, and also vaccination. Everything is registered to this application. So in this application, we can see data processing of 9 to 8 items. So when we have a look at again the Personal Data Protection Law number 6698, are these data processes in compliance with the general data protection law? In order to answer this question, we need to have a look at other regulatory processes. There are certain standards for some data processings, and as a team, we have summarized these standards in 6 different titles. As you can see, the clarification obligation and having the explicit content and data transferal, and also storage and destroyal policy of the data, and application to the data controller, and technical and other administrative precautions. In this 6th part, we can talk about this. In order not to exceed my time limitation, I'll be giving you general framework of this precautions, but in the full text of our study you can have more details if you wish. But in the very beginning, I need to emphasize one thing, esteemed guests, esteemed participants, esteemed audience. Life Fits Home Hayat Evesar application as the data controller, the Ministry of Health, when it was developed and when it was applied in line with the protection law number 6698, we can also see that the Ministry of Health can enjoy certain privileges without getting informed consent, explicit consent. Ministry of Health can use this personal data. In the Article 6 and Item 9, Item B, we can see this special exception, because in order to protect the person's health, states or the ministries should have certain data of the persons. If it is just up to the decisions of the persons, then the public health could be distorted. So in this respect, public interest is superior to person's interests. But when it comes to the person's interests, we should also say that there must be fundamental rights respect. This is essential. It should also be taken into consideration. It should never be neglected. So data controllers, public institutions, at the very top phase we can see Ministry of Health and the Ministry of Internal Affairs, should be definitely providing the balance with respect to the limitations of fundamental rights and freedoms. But I'm repeating that this is an exception stipulated in the law. Ministry of Health has this privilege, and according to the relevant law of the GDPR, starting from the Ministry of Health and other institutions of health providers, could be also among the exceptions. But still, the Ministry of Health, even though it is an exception, should be respecting democracies and rights and freedoms. Because we are a democratic country, Ministry of Health should be respecting fundamental rights. And I just want to mention those rights that the Ministry of Health is currently respecting, and at the very end I'll be providing certain recommendations for the ministry. So in the Article 5 and 6 of the law, Ministry of Health is attributed certain privileges, rights. So based on that, Ministry of Health can collect the data and process them and also transfer those data. So based on the use and the location information of the persons, big data is formed, and based on the trend of the pandemic, certain precautions could be taken. And data mining is something which we believe that is used here by the Ministry of Health, because Ministry of Health has never shared information how the system functions, but we know that mobile systems work in this respect. Based on similar mobile applications, we can understand that they also register, record their personal data and process them. This is what they do, data mining. The mostly processed location data should also be in line with the policies and legality. In the very beginning of the pandemics in 2020, April, there was this announcement shared by the Personal Data Protection Authority, and I think it's just a summary of what we are talking right now. So this is what the authority has mentioned. They say that this data could be processed by the ministry. However, this data, when there is a leakage, the individual's private life should also be disrupted. This possibility should be taken into consideration, and against these potential threats, enhancements must be made. This was a recommendation from the authority to the Ministry of Health, and the Ministry of Health has tried certain enhancements in the application, but there are still some shortcomings. First and foremost, this is a legal and acceptable application because it is asking about the explicit consent, because when it is downloaded, this consent is asked, and when it is asked, clarification and adequate level is provided by the ministry. And by the way, if you don't want to use this application, you can get your code on the e-government website, and which units are having access to this personal data on the application, this is not certain. And on the processing of this data, Ministry of Health can give authority to the companies. For that reason, extra precautions must be also obtained. Matrix preparation and double observations with some independent auditors, awareness audits must be made. These are some of our recommendations. And how long should this data must be kept? How long should this data be kept? This is an important question. Till the pandemic is over, this data could be kept and processed. This is what we believe. But after the pandemic is over, we don't know what is going to happen to this data. We don't see any elimination policy. Another problem that we see as a team are citizens who lose their lives. What happens to their codes? Or else the ones who don't want to use their data, will it be erased or not? But anyone has the right to have an access to Ministry of Health with these contact addresses, and the Ministry of Health is obliged to reply all the applications and questions within 30 minutes due to law. And under the light of GDPR articles, Life with Home application must be harmonized with the acquis, with the regulation. This is what we recommend. Thank you very much for your attention. Another recommendation of ours is that due to the legality principles, when it comes to fundamental rights and freedoms, maybe a new code could be issued for fight against pandemic. Pandevita project and other projects could be followed by this contact information. You can follow us on the social media accounts. Thank you very much. I guess I've exceeded my time. Yes, just 3 minutes. You have just exceeded your time, 3 minutes. Thank you very much for your attention. Thank you very much, Yasin Aydoğdu, for giving us a very beneficial presentation. Thank you so much. Now I'll give the floor to other presentation. Perihan Elif Ekmekçi and Latife Büşra Çokaslan prepare this document together.
Yapay zekanın tıp alanında kullanımı ve
Use of AI in the medical field and processing the personal data, ethical overview. You have 15 minutes.
Çok teşekkür ederim.
Thank you very much.
Herhalde sesim ulaşıyor size. Bir sorun olmadığını düşünüyorum. Müsaadenizle bir ekran paylaşımı yapmak istiyorum.
I would like to share my screen.
İlgili. Ekranımı görebildiğinizi düşünüyorum değerli hocalarım. Şimdi bugün benim size sunacağım tebliğ tıp fakültemizin değerli öğrencilerinden Latife Büşra Çokaslan'la beraber yürüttüğümüz bir çalışmanın
We prepared this with Latife Büşra Çokaslan from the medical faculty. This is the first step, and this study, we started this study with Berna Arda, and we made a book out of that, Artificial Intelligence and Bioethics. This is the continuation of that. This book is showing us the theoretical background of this study, the history of AI, and afterwards it's about the definition of that, and then bioethic problems, and also AI creating problems in the medical field. Now, in today's presentation, I will be focusing on the relationship of the AI with the big data and the ethical problems in terms of personal data protection. And the studies conducted about AI in 1956 in the United States in Dartmouth College. The science people came together, and this approach was first introduced by them, as you can see here in the graphic, from the summer school in Dartmouth College. These are the increase of AI studies. And AI is categorized into two, strong and weak. AI becomes strong, and it's going to bring out many ethical issues, the machine learning or deep learning. Because normally AI is a software and a computer program and getting outputs out of that. But machine learning and deep learning, they are different. It changes the game, because when we say machine learning, this program developed within the computer, it develops itself, and when there is deep learning, they're making use of the big data, and the program is developed by the system itself, and the algorithm is being changed by the creators, even by the creators. And at this very point, deep learning and big data usage in the medical ethical field, some ethical issues might arise. Before proceeding with this, let me tell you first, and we are going to write an article in a more extensive manner. When we look at the fields in which the artificial intelligence is used, like medicine, security, trade, and automotive sector, and in medical field, diagnostic purposes, for diagnostic purposes, AI is being used, and also in treatment, and also protection, as stated by the previous speaker. During the pandemic, to protect the public health, some algorithms are being developed and risk evaluation is being carried out. Therefore, these are the field of use of artificial intelligence in the medical field, and these three fields do have unique issues, ethical issues. In the diagnostic field, for example, when AI is being used intensively in the diagnostic field, human doctors are going to be left aside. The information use is decreasing, and it results in automation. And when it's being used in the treatment, the doctor-patient trust issue is being given harm. And I'm not going to go into too many details to keep our focus. Deep learning and machine learning and big data connection, where do they come from? Or AI, where do we use them? in amelioration of the health services like the medical products, medical devices, health, HR planning, service presentation, management, and another field is the pharmaceutical researches, genetic researches, and in the clinical diagnosis and prognosis processes, and the patient-specific practices, and also at the public level, like the pandemic, the risk and analysis and the real-time risk evaluation. AI might be used, as I stated earlier, the diagnostic treatment in which AI is being used. There are some structural differences from the ethical perspective, while making ethical evaluation and proposing the ethical framework for coming up solutions for that, like the AI is going to take the initiative, or it's going to be added to the decision-making mechanism, or it's becoming the authority within the decision-making mechanism. And there are some differences, but there are also some similarities among them as well, and some bioethical evaluations have to be made in that regard. When we talk about the ethical issues created by the AI, we might say that the labor force, for example, this is mostly uttered about the problems of the AI, labor force, and employment laws, because human can be substituted, and they can do that for longer periods of time with less mistake, etc. This is a serious threat to the employment. And the second one is the human relations, the issues in human relations. Younger generations know it very well. There's IRL in real life. Some relations continue, some relations are being set in the platforms shaped by the AI. Therefore, human relations are out of their natural trend, and then some ethical problems might arise as a result of that. And another one is the life skills, because in daily life AI is being used more, and some life skills are going to be transferred to the AI. So those skills get worse, and especially in the medical field, as I stated earlier, in the diagnosis and treatment area, not the life skills, but the professional skills are going to be transferred to the AI, and it's going to create a problem. Another problem is the health data. Health data, personal data, is being used as big data in the deep learning and machine learning, and the ethical issues coming with them. In 2012, another series of problems have been added in Davos Summit in 2012. Personal data, health data has commercial value, and that set of data carries a commercial value, and a new discussion was brought to the agenda. And when we talk about big data, how are they different from the other data? Variability, variety, velocity, veracity, and volume. When we talk about big data, these are the characteristics of that. The correctness of the data, the accuracy of the data, collection of data, selling of data, anonymization, transactions, and informed consent. These are the elements of the big data, and how they are being shaped. These are important elements. Why? Because the value of the data, the personal data, ethical value of the personal data. In the medical ethic, we can handle it under two titles. In the current legislation, or in the practical ethical field, mostly health personal health data is being handled as the device-like value. You know, this personal data is being kept in order to prevent something else. This is what we mean by saying device-like value. Why do we keep the personal data secret? Because we need to respect the privacy of the individuals. This is the approach of the literature. But, you know, the subject and the object is human in the medical field, and personal data, especially health data, they do have another value which is called as natural value. The individual, you know, the human dignity, protection of the human dignity, this can be considered within that framework. A researcher said for the device-like value, my car, my phone, my computer, when you say so, the value is the device-like value. But when I say my opinion, my emotions, my health, it's the natural value. It is unique to the existence of the human being. The health data within the framework of the medical ethic, because of the natural value, they need to be protected first. This is why we defend it. When we look at the resources of the health data, it's various for the diagnostic or the treatment. When you go to a hospital, for example, all the data about you become a resource to the big data. I'm not going to read all of these, but apart from that, and for personal benefit, for treatment or for diagnostic purposes, apart from those data, in non-health fields like the, you know, applications on your mobile phones or social media platforms, the data that you use there, they might be the source for the big data in the medical field. For which purpose this big data is being collected? There's the commercial component. The second one is the service to the humanity, as stated by the previous speaker. This is for the benefit of the public, like the pandemic, etc. And the other one is the development of the AI, creating more correct, more accurate AIs for self-education of the AIs. For which purposes can this be used, this big data? Multifactorial diseases for the treatment of cancer. And the second one is the personalized medicine. The individual has his unique approach, you know. That person is not prescribed the medicine, general medicine, but, you know, but personalized medicine and precise medicine as well. And what about the law and the regulations? Article 28C of the Personal Data Protection Code. When health data is going to be used for scientific purposes, there are exceptions. And for protection of the public health and for planning the financing the health services without the open consent of the related, health data can be processed. On the other hand, clinical researches on the human, when we look at the local regulation, Helsinki regulation says that the privacy and the secrecy of the research people, they need to be protected. And again, Health Services Fundamental Code 10th article, in the clinical researches, the individual's health and rights should be protected, and it's above all. Therefore, there's an exception for the process of that. But Helsinki Act and also this fundamental law of health services are not supporting them. Scientific researchers, when we talk about them, they do have differences among themselves, one of which is the genetic researches, for example, with the data of a person. If you are conducting a genetic researches, not only that person, but also all the people connected to that person genetically. So you are getting personal data out of that. So the sensitivity should be there, especially while transferring big data to the AI. The ethical usage of the personal data and commercializing them. There are two arguments. The first one is the anonymization, and the second one is the informed consent. The data is going to be made independent from the owner of the data, and then that data becomes anonymous. So ethical issue has been overcome. Could you please wrap up? About anonymization, if you're going to conduct a research on human, like the retrospective research as well, or you're going to make a research by making use of the research, then that person that you're making experiment on, if there is a benefit that you can provide to that person, then that benefit has to be provided to that person.
Hemen toparlıyorum. O zaman bunun detayına girmeyeyim. İnşallah makalemizde bunun daha detayını görebiliriz. Onanda pek çok sorun var.
And there are many issues in informed consent as well. I don't want to go into detail about that as well.
Konusundaki hassasiyeti anlıyorum ve önemsiyorum. O nedenle şu şekilde de toparlamış olayım tekrar. Evet. Kısacası şunu söylemek istiyorum. Yapay zekanın tıp alanında,
to sum up the use of AI in the medical field, especially with the use of big data. So having an informed consent or making it anonymous are not solving the ethical issues, because the subject and the object of the medical field is human. Therefore, it should be balanced with the human dignity, and special regulations are required in that regard. And thank you very much for your patience. Thank you. You gave us hope on one side and you gave us concerns on the other. AI is going to make our lives easier. Thank you very much. And this is the last session, so we are more sensitive to the time because everybody is tired. Okay.
Diyorsunuz. Artık bunu tam metinlere bırakalım bir kısmını. Evet, sırada Mehmet Akçaal var. Kendisi bize özel...
Thank you very much. Now Mehmet Akçaal will be talking about the compensation of the indemnity.
Teşekkür ederim hocam. Saygılarımı sunarım. Değerli katılımcılara ve kıymetli dinleyicilere de saygıyla selamlıyorum.
I'd like to extend my salutations all the speakers. I'll be talking about the moral damage caused by violation of private personal data.
Niteliğindeki özel nitelikli kişisel verilerin ihlalinden doğan manevi zararın tazmini meselesini çok kısa bir şekilde ele alacağız. Daha sonra ayrıntılı olarak
very briefly I'll be talking about that. Then in the written form, in the text, you can find the details. When you have a look at the personal data and its specialities, its kind, we can also define personal data like this. it could be defined as all kinds of data relating to a certain person. The definition of personal data is clearly included in the law number 6698 on the protection of personal data. Accordingly, personal data means any information relating to an identified or unidentifiable natural person. In this case, it is possible to talk about three elements of personal data. These are information, an identified or identifiable natural person, and information relating to this person. Personal data may be subject to various distinctions. Among them, the basis of the law on the protection of personal data, number 6698, is a distinction between special personal data and general personal data. As I've stated beforehand, there are three important factors, elements for the personal data: information and identified or identifiable natural person. For instance, ID number and also fingerprints are the instruments for identifying a person. And the last element is related to the personal data, which is related to that person. For instance, the health, sex, or criminal record information of the person is personal data. Personal data, as I've stated beforehand, could be subject to various distinctions. Among them, there is this basis of the law on the protection of personal data. And there is also, again, the distinction between special personal data and general personal data. After talking about special personal data, I'd like to talk about whether it can lead to compensation for moral damage. On the special personal data, we can see that if this is disclosed to others, it might cause the person concerned to become a victim or be exposed to discrimination. This data could be also accepted as sensitive personal data. And in the Article 6, Paragraph 1, special personal data is listed. According to that, we can talk about the race, ethnicity, political opinion, philosophical belief, and also sects or other beliefs, disguise and dress, association, foundation, or trade union membership, health, sexual life, criminal conviction, especially in terms of right to be forgotten, criminal conviction and security measures. As you all know, these are very crucial. Biometric and generic data are also personal data. These are having this special nature. Special personal data are limited. And these might stigmatization for these people in the society. This is very sensitive. And we have this principalities. With the examples, this set of data can't be enlarged, and in the GDPR Article 9, special personal data is already listed, and there is this rule, the jurisdiction law by the legislator. General, unlike the concept of special personal data, the concept of general data is not explicitly included in the law, and this could be like the phone calls or others. General personal data can be defined as all personal data other than special categories of personal data. An example of general personal data is the person's identity number. And general provisions on the protection of personality, Turkish Civil Code Article 2325 and Turkish Code of Obligations Article 58 are also considered in terms of unlawful processing of special personal data within the scope of personality rights. But it's open to discussion. Indeed, a special personal data within the scope of the personality right may be processed without the consent of the person. The regulations that protect the personality against wrongful acts of third parties are important, and also It can be said that two conditions are sought in order to apply for the ways of protecting the personality. These are the existence of an unlawful act against personal rights and the absence of a reason for compliance with the law. This must be also described as personality rights, and illicit, illegal acts presence is sought here if we want to talk about personality rights. For instance, stigmatization, which is against law, could be the example.
Kişisel verilerin korunması kanununda ilaveten saymaktadır. Mesela bir kişinin
For instance, consent of a person could be mentioned again. If there is unlawful act against the personal right, the person is protected against the person who interferes with the personal right. In that case, the act must be first against the law. In order for an attack on personal rights to be unlawful, there must be no justification for the law. If we have a look at this attack over the personality rights, if there is moral damage, that damage must be compensated. It is possible for that person to ask for moral damages. And in the material indemnity cases, here personal data should be processed against the legality. Illegal processing of the data is the prerequisite, and the negligence doesn't have to bear some aggravation or some heavy conditions. Another important thing we are looking for is that this illegal processing should also be mistaken. It should be intention or else negligence. So especially in this special personal data, this is practically important because it could be subject to moral damage compensation. And as a matter of fact, according to a decision of the Supreme Court Appeals General Assembly, place of birth, date of birth, father's name, citizenship status, and religious beliefs included in the news content without the consent of the plaintiff are in the nature of the personal data. And here we can talk about the violation of the personality rights, so moral damages must be compensated. Again, the plaintiff, which is the victim of the sexual harassment, if it is explicitly mentioned in a book, it violates the privacy of the private life and the secrecy of the life. So the decree should be for the compensation of the moral damages. And the moral damage is a right given to the person. It can't be transferred to other people. And some amount of money could be demanded for the victim of this case as the compensation of the moral damages, and there is a statute of limitations. This is also again a lawful act according to the 72nd article of the Turkish Code of Obligations. It has certain other details. I am the last speaker. I have both advantages and disadvantages. I know that people are tired. That's why I don't want to push your patience too much. In the last part, I want to talk about parties' status with respect to demand for moral damages compensation. First and foremost, there is the person whose personal data is violated. Personal data definition must be taken into consideration because only natural persons' personal data is under protection by the legislator. For that reason, under the personal data protection law, We cannot talk about the right to open up a court case for legal personalities, but there are some exceptional arrangements for legal personalities as well. We have to remind you of them. So the defendant side is the party which violates personal data in an illegal way. And defendant here is the controller of the data. It could be a natural person, it could also be a legal person. There is no limitation. On contrary to the plaintiff itself, it can also be a legal person. For instance, special personal data, when it is processed illegally, then there could be compensation of the moral damages from the legal personalities. Personal data, if it is processed by third parties, then this is also something to be discussed according to the relevant paragraph of the Protection Law number 6698. Security of the data related principles must be implemented. It says that there is this principle of reciprocity. So if plaintiff desires, he or she can sue the data controller or else the third party. Because it's the last presentation of the day, that's why I will just cut it here. Thank you very much. Thank you so much for your kind words. Thank you very much. Thank you so much. So we have come to the end of this day. I'd like to thank the organizers for this Congress. Thank you very much, all the team members, all the institutions. I wish there will be many more of this Congress. Thank you so much. So thanks to this Congress, we have raised awareness with respect to personal data protection. Different people can submit their opinions. Tomorrow we will be again here. And good evening everyone. Thank you.
Konuşmacılarımıza ve oturum başkanımıza katkılarından dolayı çok teşekkür ediyoruz. Değerli katılımcılar ve bizi ekran başında takip eden izleyicilerimiz, kongrenin ikinci...
We have come to the end of the second day. Thank you very much for your participation, and we will be tomorrow. We will be here tomorrow with different speeches and speakers. Thank you very much.